5 seconds to go. Start. The petitioner was appointed as lecturer in mathematics in the Institute of Engineering and Rural Technology, Allahabad, on 6 September 1983. The petitioner's wife, Dr. Sarita Srivastava, joined as lecturer in Sanskrit in the Raja Shri Tandon Mahila Mahavidyalaya on 31st March 1989. Both the petitioners were receiving house rent allowance from their respective institutions till January 1996, when the house rent allowance of petitioner's wife was stopped by the principal on the ground that she is not entitled to receive the same, since her husband is already receiving the house rent allowance. The petitioner gave in writing that the house rent allowance to the petitioner be not paid and the house rent allowance to the petitioner's wife be restored with effect from March 1996. The house rent allowance of the petitioner was stopped and that of his wife was restored with effect from March 1996. The petitioner submitted a representation on 17th February 1997 to the Director IERT seeking payment of house rent allowance as well as arrears of house rent allowance on the strength of the division bench judgment of this court in the case of Dr. Maya Rani Srivastava versus Director Higher Education UP Allahabad and others, AIR 1998 SC 157. The petitioner submitted reminders. The Director IERT, by order dated 5th September 1997, directed for payment of house rent allowance to the petitioner, in pursuance of which the Joint Director Technical Education Varanasi started payment of house rent allowance to the petitioner from October 1997. The petitioner thereafter submitted another representation for payment of arrears of house rent allowance from March 1996 to September 1997. On such representation of the petitioner, the Director Technical Education wrote to the state government seeking appropriate direction for stopping the house rent allowance of the petitioner. In the reference letter dated 11 July 2000 of the Director Technical Education, it was stated that when husband and wife both are residing in the same city and in the same house, both are not entitled for house rent allowance, and the judgment of this court in Dr. Maya Rani's case supra cannot be applied in all matters. The state government wrote a letter on 21st October 2000 to the Director Technical Education, after receiving which letter the Director Technical Education issued an order dated 10th November 2000 for stopping the payment of house rent allowance to the petitioner and for taking steps for recovery of irregularly paid house rent allowance to the petitioner, and further to submit a report of responsible official in that regard. This writ petition has been filed by the petitioner challenging the aforesaid order. In the counter affidavit filed by the state, it was stated that in view of the clear policy of the state that if husband and wife both are in the government service, the house rent allowance is not payable to both of them. Hence, the order issued were perfectly in accordance with law and the petitioner was not entitled for payment of house rent allowance. Stop.